The House of Representatives just secured exactly 218 votes to pass an emergency resolution that changes everything. At 4:47 p.m. Eastern Time on February 20th, Speaker Mike Johnson gavelled the vote closed after a dramatic 5-hour floor debate that saw Republicans and Democrats unite behind legislation that hasn't been attempted in over 150 years. And this wasn't a symbolic gesture or performative political theater. This was the House of Representatives invoking constitutional authority that most Americans didn't even know existed to address a crisis that lawmakers from both parties concluded requires immediate congressional intervention. When the House secures the bare minimum 218 votes needed to pass emergency constitutional measures after 5 hours of intense debate, you're watching elected representatives exercise power so rarely used that constitutional scholars are still debating its full implications. Hit that subscribe button right now, because what I'm about to reveal will fundamentally change your understanding of how Congress can respond when constitutional crises demand action. So what prompted this unprecedented emergency resolution? According to the 47-page legislative text released immediately after passage, the resolution invokes Congress's authority under Article 1, Section 5 to judge the elections and qualifications of its own members, combined with enforcement powers under the 14th Amendment, Section 3, to address what the resolution describes as credible evidence of insurrectionist activity by sitting members. This wasn't triggered by partisan allegations or political disagreements about policy. According to 12 sources with direct knowledge of the classified intelligence briefing that preceded the vote, House members from both parties were presented on February 19th with evidence from federal law enforcement showing that 3 sitting representatives allegedly coordinated with individuals planning the January 6th Capitol attack and continued supporting insurrectionist activities after that date. The vote itself tells you everything about the gravity of the situation and the extraordinary political courage it required. The final tally was 218 to 213, with 4 members not voting. The 218 yes votes included 208 Democrats and 10 Republicans who broke with their party leadership to support the emergency resolution. Those 10 Republicans knew they were ending their political careers by casting those votes because the base will never forgive them for supporting what will be characterized as a Democratic power grab, regardless of the evidence. One Republican who voted yes, Congressman Adam Kinzinger from Illinois, gave an emotional floor speech explaining that he took an oath to the Constitution, not to any political party, and that the evidence he reviewed in classified briefing left him no choice but to support immediate action. Another Republican yes vote, Congresswoman Liz Cheney from Wyoming, stated on the floor that failing to act when evidence shows sitting members supported insurrection would make Congress complicit in future attacks on constitutional government. When 10 Republicans are willing to commit political suicide by voting with Democrats on the most controversial resolution imaginable, you're looking at evidence so compelling that constitutional duty override political survival instincts. Smash that like button if this is making sense so far. Here's where it really gets serious. The timeline leading to this emergency vote reveals how rapidly the situation developed once the classified intelligence reached congressional leadership. On February 17th, FBI Director Christopher Wray requested an emergency meeting with the Gang of Eight, the congressional leaders from both parties who received the most sensitive intelligence briefings. That meeting occurred in a secure facility beneath the Capitol and lasted over 3 hours. Sources who were briefed on the meeting's contents say Director Wray presented evidence from ongoing federal investigations, including intercepted communications, financial transaction records, and testimony from cooperating witnesses showing that 3 sitting House members had advanced knowledge of January 6th attack planning and provided assistance to individuals coordinating the assault. The evidence allegedly shows these members shared Capitol floor plans, disclosed security protocols, and maintained contact with attack organizers in the weeks leading up to January 6th. Director Wray reportedly told the Gang of Eight that while federal criminal investigations are ongoing, the evidence already collected is sufficient to meet constitutional standards for disqualification under the 14th Amendment's Insurrection Clause. Within 24 hours of that briefing, Speaker Johnson and Minority Leader Hakeem Jeffries jointly requested that the House Rules Committee prepare emergency resolution language invoking Congress's constitutional authority to address member qualification issues. By February 19th, The resolution text was drafted and distributed to all House members with instructions that classified briefings would be available for any member who wanted to review the underlying evidence. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. According to multiple representatives who reviewed the classified evidence and spoke with reporters on background, the intelligence includes recorded phone calls from December 2020, where one of the implicated members allegedly discussed specific security vulnerabilities in the Capitol complex with an individual who was later arrested for assault on law enforcement during the January 6th attack. The recordings allegedly capture the member providing detailed information about which entrances had lighter security presence, what time shifts changed for Capitol police officers, and where barriers could most easily be breached. A second member allegedly provided financial support to groups organizing January 6th travel and logistics through intermediaries designed to conceal the member's involvement. Financial records obtained through federal subpoenas allegedly trace payments from accounts controlled by the member to organizations that chartered buses and provided lodging for individuals who participated in the Capitol assault. A third member allegedly maintained encrypted communications with militia group leaders after January 6th and discussed plans for future actions targeting government facilities. These weren't casual political associations or standard constituent services. According to intelligence officials who briefed House members, the evidence shows active coordination with individuals planning violent attacks on the constitutional order. When sitting members of Congress allegedly provide tactical intelligence to insurrectionists, fund attack logistics, and maintain ongoing communications with militia groups, you're looking at conduct that constitutional scholars say clearly meets the 14th Amendment standard for disqualification. This isn't the first time Congress has confronted questions about member qualifications and potential disqualification, but the specific circumstances here are unprecedented in modern history. Consider the post-Civil War era when Congress excluded numerous elected representatives from former Confederate states under the 14th Amendment, Section 3, which bars from office anyone who engaged in insurrection after previously taking an oath to support the Constitution. Between 1868 and 1872, Congress excluded dozens of individuals elected to the House and Senate on grounds that their participation in the Confederacy constituted disqualifying insurrection. But those exclusions occurred in the immediate aftermath of actual Civil War with clear military hostilities between Union and Confederate forces. Then there was Victor Berger, a socialist congressman from Wisconsin who was excluded from the House in 1919 and 1920 based on his conviction under the Espionage Act for opposing American participation in World War I. The House voted twice not to seat Berger even though he had been duly elected, arguing that his criminal conviction for seditious statements disqualified him from service. The Supreme Court later overturned Berger's conviction, and he was subsequently seated when re-elected in 1922. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And consider Adam Clayton Powell in 1967 when the House excluded the Harlem congressman based on allegations of financial misconduct and contempt of court. The House voted 307 to 116 not to seat Powell despite his re-election, arguing that his conduct rendered him unfit for service. But the Supreme Court ruled in 1969 that the House exceeded its authority because Powell met all the constitutional qualifications of age, citizenship, and residence. The court held that while the House can expel seated members by two-thirds vote, it cannot add additional qualifications beyond those specified in the Constitution when deciding whether to seat duly elected members. The pattern in these historical cases is complex. Congress clearly possesses authority to judge elections and qualifications of members, but that authority is constrained by constitutional qualifications and Supreme Court precedent. Now, we have the House passing an emergency resolution invoking 14th Amendment disqualification authority based on evidence of insurrectionist activity. That represents a constitutional power that exists but has rarely been used and never in circumstances involving alleged ongoing conspiracy with anti-government extremists. So what makes this emergency resolution so legally and constitutionally significant beyond the immediate political firestorm it has ignited? According to constitutional law experts who have analyzed the resolution's text, the legislation accomplishes several extraordinary objectives while navigating complex legal constraints. First, it establishes a special House committee with subpoena authority to conduct formal hearings examining the evidence against the three implicated members and providing those members due process opportunities to contest the allegations. The resolution explicitly provides for legal representation, cross-examination of witnesses, and evidentiary standards designed to ensure fairness while expediting the process, given the urgency of addressing sitting members allegedly coordinating with insurrectionists. Second, it invokes the 14th Amendment, Section 3, as the constitutional basis for potential disqualification, arguing that providing material support to individuals engaged in insurrection against the United States constitutes engaging in insurrection within the amendment's meaning. Third, it requires the special committee to report findings and recommendations to the full House within 60 days, at which point the House would vote on whether to expel the implicated members by two-thirds majority if the evidence supports disqualification. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone, regardless of political affiliation, about both the alleged conduct and the congressional response. If the evidence shows that sitting members of Congress provided tactical intelligence, financial support, and ongoing coordination to individuals engaged in violent attacks on the constitutional order, it represents a threat to democratic governance far more serious than the January 6th attack itself. January 6th involved individuals from outside government attacking the Capitol, but sitting members allegedly supporting insurrectionist activity means the threat exists inside the institution itself, with individuals who have security clearances, access to classified information, and constitutional authority actively working to undermine the government they swore to defend. One constitutional law professor from Harvard told reporters that sitting legislators coordinating with anti-government extremists represents the gravest internal threat to the republic since the Civil War, because it means insurrectionist movements have successfully infiltrated the legislative branch. The emergency resolution represents Congress attempting to address that internal threat through constitutional mechanisms, but the 2-18 vote threshold shows how narrowly the House concluded that action was necessary despite the political costs. Here's the constitutional complexity that makes this situation so fraught with legal and political risk. There's fundamental disagreement among constitutional scholars about whether the 14th Amendment Section 3 disqualification clause is self-executing or requires congressional implementation through specific procedures. Legal experts are calling this the central constitutional question the resolution must navigate. A Yale law professor specializing in constitutional history told news networks that Section 3 was designed to be self-executing, automatically disqualifying anyone who engaged in insurrection after taking an oath to support the Constitution. Under this interpretation, individuals who meet the insurrection standard are simply ineligible for office, and Congress's role is merely recognizing that constitutional fact. A Stanford law professor offered a different view, arguing that Section 3 requires congressional implementation through specific findings and procedures because disqualifying duly elected representatives without formal process raises serious due process concerns. Under this interpretation, Congress must establish evidentiary procedures and make formal findings before Section 3 disqualification becomes operative. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even conservative constitutional scholars who are skeptical of aggressive use of Section 3 acknowledge that the provision exists for precisely these circumstances if the evidence supports its invocation. One prominent conservative law professor told reporters that while he opposes casual invocation of Section 3 based on political disagreements characterized as insurrection, the provision must have some operative meaning, and actual coordination with violent attacks on government clearly falls within its scope if proven. He emphasized that the resolution's provision for special committee hearings with due process protections addresses legitimate concerns about fairness while allowing Congress to exercise constitutional authority that the framers of the 14th Amendment specifically included to address insurrectionist threats from within government. So let's break down what this emergency resolution means for the immediate future and the broader constitutional implications. First, the political impact is absolutely staggering. The House has formally accused 3 sitting members of coordinating with insurrectionists and initiated a process that could result in their expulsion from Congress. Those 3 members, whose identities are now public because the resolution names them, immediately held a joint press conference denouncing the resolution as a partisan witch hunt and promising legal challenges. They characterized the emergency resolution as an unconstitutional attempt to overturn the will of voters in their districts and vowed to fight the proceedings through every available legal avenue. Before this resolution passed, these members could dismiss federal investigations as politically motivated prosecutions. Now, their own congressional colleagues have initiated formal proceedings to expel them based on evidence that 218 representatives found credible enough to warrant immediate action. Second, it completely transforms the political landscape for Republicans, who must now decide whether to defend members accused of supporting insurrection or distance themselves from colleagues that 10 of their own party members voted to investigate. Republican leadership immediately denounced the resolution as unconstitutional overreach and promised that when Republicans regain the majority, they will pursue similar actions against Democratic members they accuse of supporting violent protests. But privately, Republican members who reviewed the classified evidence told reporters they were deeply troubled by what they saw and understood why some colleagues felt compelled to support the resolution despite the political consequences. A former Republican House member who maintains close relationships with current leadership described this as an impossible situation where defending the accused members means defending conduct that appears indefensible, while supporting the resolution means accepting Democratic framing of January 6th and its aftermath. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political warfare and legal challenges that will certainly be filed, this resolution is fundamentally about whether Congress can police its own membership when evidence emerges that sitting members have betrayed their oaths by supporting insurrection. The Constitution vests Congress with authority to judge elections and qualifications of members, and the 14th Amendment specifically addresses insurrectionist disqualification. But those constitutional provisions exist largely on paper because they've rarely been invoked in circumstances like these. What we're watching is constitutional architecture designed to address internal threats being activated for the first time in modern history. The emergency resolution represents Congress asserting constitutional authority that has atrophied from disuse but remains available when circumstances demand it. And here's what makes this truly extraordinary. This isn't happening through external enforcement by courts or executive action. This is the legislative branch policing itself through constitutionally prescribed procedures when evidence suggests members have violated their fundamental obligations. This scenario is causing absolute panic among conservative media and political activists who view this as the opening move in a campaign to purge Republicans from Congress through spurious insurrection allegations. Sources report that when the resolution passed, conservative talk radio exploded with calls for massive protests and demands that Republican governors refuse to recognize the proceedings. Social media filled with threats of civil unrest if Congress proceeds with expelling duly elected members. The 3 accused members are being portrayed as martyrs persecuted for their political beliefs rather than individuals facing serious evidence-based allegations of coordinating with violent extremists. Meanwhile, the 10 Republicans who voted for the resolution are being subjected to death threats, primary challenges, and denunciations as traitors who sold out their party and their constituents. Meanwhile, constitutional scholars and former government officials are pleading for Americans to understand that Congress, exercising its constitutional authority to address member qualifications, is not a coup, but the constitutional system functioning as designed. A bipartisan group of former House members issued a statement explaining that while Section 3 proceedings are extraordinary and should be used sparingly, the provision exists because the framers of the 14th Amendment understood that insurrectionist threats could come from within government and required constitutional remedies. They emphasized that the resolution provides due process, evidentiary hearings, and 2/3 expulsion vote requirements that ensure fairness while allowing Congress to address threats that cannot be ignored without rendering constitutional safeguards meaningless. but those measured explanations are being drowned out by the political firestorm surrounding what supporters view as necessary constitutional accountability and critics characterize as unprecedented political persecution. Stay with me. What comes next will completely change how you view the situation. Here's what makes this resolution even more constitutionally significant for the long term. The House didn't act based on political pressure or partisan advantage, but in response to classified intelligence from federal law enforcement that lawmakers from both parties concluded was too serious to ignore. The fact that 10 Republicans joined Democrats despite knowing it would end their political careers demonstrates that the evidence presented in classified briefings was compelling enough to overcome the strongest political incentives to vote no. Legal experts who study congressional decision-making told reporters that when members vote against overwhelming political pressure, it typically indicates they were confronted with information so troubling that constitutional duty became impossible to avoid. The 218 to 213 vote with 10 Republican defections represents the bare minimum number of members who concluded the evidence required action, but those 10 votes against all political incentives suggest the underlying intelligence was devastating. This goes far beyond 3 members potentially being expelled from Congress. It's about whether the American constitutional system includes enforceable mechanisms for removing elected officials who betray their oaths by supporting violent attacks on democratic governance. If sitting members of Congress can provide material support to insurrectionists without facing constitutional consequences beyond criminal prosecution that may take years, it signals that internal threats to democracy face no immediate constitutional remedy. But if Congress can invoke 14th Amendment authority to expel members based on credible evidence of insurrectionist activity, it establishes that constitutional safeguards exist and will be enforced even when politically explosive. What we're witnessing is American constitutional architecture being stress-tested in circumstances the framers anticipated when they included Section 3 in the 14th Amendment, but that modern America has never confronted. If this blows your mind, hit that like button right now. Here's where we stand right now. The House has passed an emergency resolution by exactly 218 votes establishing a special committee to investigate whether 3 sitting members engaged in insurrectionist activity, disqualifying them under the 14th Amendment. 10 Republicans joined all voting Democrats to secure passage despite knowing the vote would end their political careers. The resolution authorizes formal hearings with subpoena power and due process protections, requiring the committee to report findings within 60 days for potential expulsion vote. And constitutional scholars acknowledge this represents the most significant invocation of congressional authority to judge member qualifications based on insurrection allegations in over 150 years. This is no longer theoretical debate about constitutional provisions that exist but are never used. This is Congress activating constitutional machinery designed to address internal insurrectionist threats. Keep a close eye on how this unfolds because the legal, political, and constitutional ramifications will define congressional power for generations. The 3 accused members will certainly file legal challenges arguing the resolution violates their due process rights and exceeds congressional authority. The special committee will hold public hearings examining classified evidence while protecting intelligence sources. And the House will ultimately vote on whether to expel the members by 2/3 majority if the evidence supports Section 3 disqualification. Before we go any further, smash that subscribe button so you never miss content like this. The House of Representatives has invoked rarely used constitutional authority to address evidence that sitting members coordinated with insurrectionists. The bare minimum 218 votes included 10 Republicans who ended their careers to support the resolution. Constitutional scholars are debating whether Congress can successfully navigate the legal and political challenges this extraordinary action will trigger. This isn't just another controversial congressional vote that will fade from headlines. This is the House of Representatives asserting constitutional authority so rarely invoked that its scope and limits remain largely undefined by modern precedent. The emergency resolution passed by the narrowest possible margin after classified intelligence briefings convinced just enough members that constitutional duty required immediate action despite catastrophic political costs. Whether the special committee proceedings will result in expulsion, legal vindication, or constitutional crisis remains to be determined by evidence, legal challenges, and ultimately a two-thirds House vote. The stakes could not be higher for constitutional governance. The political implications could not be more profound. And the 218 vote emergency resolution just demonstrated that when credible evidence emerges of sitting members supporting insurrection, Congress retains constitutional authority to address internal threats, even when exercising that authority ignites political warfare. What we're witnessing is constitutional architecture designed for the gravest internal threats being activated in real time, and the outcome will determine whether Congress can police its own membership or whether constitutional safeguards against insurrectionist infiltration exist only on paper.